He laughed while the cameras rolled. Not a nervous chuckle or a private snort, an open, bright laugh that sounded like triumph. It filled the marble rotunda, bounced off columns, landed in phone microphones, and on the shoulders of strangers who would, within hours, press share and retweet without knowing the whole story. He held a stack of papers like a prize. He pointed, mocked, and when she steadied herself and met his gaze, he laughed again as if the sound could finish what his words began. To erase her. That moment, bright lights, a serrated laugh, the slow walk away, would travel faster than any apology could follow. It would become a line of text in headlines. Lawyer laughed, while ruining her life. It would become a pulse in the feeds of people who had never met either of them. It would be the beginning of something neither man had planned, a long, unpardonable reckoning. Viola Mercer learned early how to hold a room without raising her voice. She preferred facts over flourish. She preferred to let evidence do the talking, to let timelines and documents fold around an argument until there was no room left for doubt. By 46, she had a reputation that came in small, hard-earned pieces, briefs that never missed a precedent, a reputation among judges for clarity and among clients for quiet tenacity. She wore sensible suits. She read on late trains. Her desk had a single-framed photograph. Her father in a battered suit watching her graduate law school, proud without pose. It isn't dramatic to say she had everything to lose. In the legal world, everything means a reputation that moves slowly, but is fragile when tugged. She did not expect to be humiliated in public. She thought that should be the province of the less careful. She had built a career excelling at the kind of work that happens between filings, settlements, negotiations, the paperwork that muffles the noise. She was a fixer, a counsel people trusted to make ugly problems small. On that Wednesday morning, she was minding an appointment she had set with a municipal panel, an advisory hearing meant to surface complaints about the city's contracting practices. She had represented a neighborhood association in a civil oversight petition. She had read the documents twice, had a 30-page brief that summarized her client's claims, and had every intention to speak quietly, to make the case and go home. Brett Kowalski ran on a different current. He moved through rooms the way some people move through water, without apparent effort but with a force people noticed afterward. He was the kind of litigator who had made a life out of spectacle. High-profile clients, pro bono headlines, carefully placed op-eds that appeared in the morning papers when he wanted a sympathetic narrative. He wore a tie that looked expensive and a confidence that looked practiced. He laughed at witness testimony in ways that could look like disdain and, often enough, feel like entertainment. His firm had done well for decades. It had deep pockets, shallower apologies. Brett was the sort of lawyer who believed in law as theater, in how a gesture, an unpaved eyebrow, could dissolve a witness. For him, the legal system was instrument and performance at once. If his client wanted a spectacle, Brett would deliver one and file the controversial motion to make sure everyone watched. That day, the rotunda filled with people who had come for a different reason. A parade of TV vans lined the curb under a blue sky. A cameraman hovered, a little too eager for the second that would make his reel. Brett had arrived with a press release and a smile that read like a script. He did not need to shout. He could not help but perform. He walked toward Viola with the swagger of someone certain the world would be on his side. When he produced his papers, allegations framed in bold type, a list of accusations about procedural missteps, a complaint that suggested misappropriation of funds, he announced it to the microphones as though laying down a gauntlet. He told the press that he was there to protect the public interest, then tilted his head and let the camera find Viola. He laughed before anyone asked a question. It was a laugh that suggested the outcome was preordained, a settlement, a resignation, a place for headlines that promised closure. For a few minutes, people believed him. The city, always hungry for a clean narrative, issued a statement that afternoon calling for investigations in the public interest. That phrase would sound neutral on the mayor's webpage. For Viola, it became the start of a storm. Leo, who jogged the park route every morning, kept his phone in the armband like a talisman. He'd learned in smaller ways how to document the city passing by. That morning, He recorded a short clip as he slowed to navigate the crowd outside the municipal building. The clip that fixed the sound of Brett's laughter to a face and pinned Viola's measured composure beside it. Leo didn't expect the video to leave his phone. He uploaded it to a local neighborhood group, half as curiosity and half as a civic record. Within 3 hours, someone with thousands of followers amplified it. Within 5 hours, local talk shows had looped the laugh. Within 12, the video had hundreds of thousands of views and people had already decided what it meant. 3 minutes later, the internet decided, the narrator might say, if there were such a narrator, and in this city the internet rarely deliberated. It judged. The clip edited itself into 1,000 versions. In some edits the audio explodes, the laugh looping like a taunt. In others, the caption asks, "How do we live in a system where one man can destroy someone else with a grinned accusation?" People took sides in a language of quick morals. Some called Viola a villain, receptive to the script Brett had offered. Others recognized the pattern of spectacle, the sudden accusation, the well-timed press release, the parade of legal op-eds that followed. The professional consequences were immediate in a way that sometimes only reputations learn to dread. The Bar Association flagged a temporary review. The Oversight Office placed her status under inquiry, not a punishment, but a cloud. Enough for some clients to reconsider, for some institutions to step back. Invitations were rescinded. Partners' phones lit up with messages from anxious people who had nothing to do with the initial incident, but who had watched the clip and calculated risk. Viola swallowed a dozen indignities with the calm of someone who had handled worse. Sloppy procedural attacks, a rival who had ambushed her in a memo, a city official who adopted convenient silence. She set her jaw, worked the phone, told her assistant to gather every file on the municipal petition. She did what she always did, prep. And when the bar asked for an initial statement, she prepared one that was precise, not pleading. But there was a line that had to be drawn. This, she told Elena Ross, the young associate who became her shadow, was not about pride. It was about the truth. "If we let the narrative be created for us," Viola said, "they own what comes next." Elena was 29, a Princeton undergrad, sharp eyes behind thick glasses with a notebook full of questions. She had interned with Viola the summer after law school and never left. She had an appetite for the kind of research that turned rumors into discoverable facts. "Start with the chain," Viola told her. "Who drafted their release? Where did their talking points come from? Who called the reporters that pushed it?" They began looking for breadcrumbs, timestamps on press releases, the IP address that uploaded the first copy of Brett's statement, phone logs that showed a pattern of calls between the firm and a local broadcaster during the exact minutes the complaint went public. The first week was a rinse of mundane bureaucratic brushwork, calls returned late, requests for documents stalled with procedural evasions. It would take work to turn this into something that could stand in court. That was the point. Publicly, Brett doubled down. He gave interviews in which he gestured as if he were arranging a set. He said he had no interest in theatrics, and then told a late-night host that he had simply done the right thing. Privately, his messages were less buttoned down. One journalist leaked a recording where Brett could be heard telling a staffer that the idea was to make her look inevitable and that the firm would lean on regulatory boards hard. Those phrases, leak, inevitable, lean on, would be gifts if the right hands could get them into evidence. A pattern is, after all, often a pattern because someone left tracks. Viola's first legal move was not dramatic. She filed protective motions and sought a temporary restraining order to prevent any further defamatory press releases based on confidential filings. Simultaneously, she sent a demand letter. Retract their allegations or face litigation for defamation, tortious interference with prospective economic advantage, and intentional infliction of emotional distress. These are old claims, blunt instruments in the arsenal of reputation law, and they can be bluntly effective when paired with documents. If Brett had expected a quick fold, if he imagined his video-boosted spectacle would make Viola disappear, he miscalculated. Instead of a public apology, Viola sought truth on the record, She refused hush money offers and refused to negotiate behind curtains. There was a calculation behind it. A public record mattered more than quick cash. Once a thing is public, a settlement that keeps no record is an insult. Better to force the light. Better to let discovery do the heavy lifting. Discovery is not fast. It is not always cinematic. It is work in rooms with fluorescent light, where people move through boxes of old emails, call logs, billing records, and company memos. But discovery is where patterns show themselves like seams in clothing. Elena dug into metadata. Arthur Sterling, an old friend and an influential counsel who had once shared a courtroom with Viola, helped by filing subpoenas and by making calls that opened closed doors. They found a handful of messages that would later look like a constellation, scheduling notes that hinted at coordinated media placement, draft press releases labeled for immediate release, with versions saved by a junior partner who had since deleted his account, an internal memo at Brett's firm listing strategic outcomes and pressure points. Those documents did what Viola hoped. Once you put them on the table, the other side had to explain them. Meanwhile, the public case expanded. People outside the law began to treat the incident as a referendum on more than just one career. It became about how power could be weaponized against someone without the same resources to fight back. Talk shows spun it into sound bites about the rich and powerful. Grassroots organizers took up Viola as a symbol, not because she needed the charity, but because a story where an institution could be questioned felt like a small victory. For Viola, the attention was a tool and a hazard. Tools can cut. Brett's confident laugh had consequences he had not calculated. It made him a character in the stories that churned in feeds. It put his demeanor, callous, dismissive, on loop. People began to find old items that fit a narrative of arrogance. A college speech where he joked about taking the gloves off. A charity event where he had mocked a critic. Humans are pattern-seeking. When you give them a laugh, they imagine all the punches that led to it. Institutional responses followed the rhythm of media cycles. The mayor issued a statement about an independent review. The state bar said it would look into the complaint. The firm's PR machine, worried about clients and an eroding brand, circulated a defensive memo that tried to reframe the narrative. Brett was a zealous advocate, and the allegations were an unfortunate misunderstanding. The memo did not mention Leo's clip. In a deposition room months later, which would become one of the central stages of the fight, Brett sat in front of a table, a microphone turning morning coffee into a confessional. He wore a navy suit and the expression of a man who had survived 1,000 cross-examinations. His answers were sharp, sometimes rehearsed. When asked why his office had released a particular statement, he described strategic communications. When asked about the intent behind certain phrases, he said again and again that he had no intent to harm. Intent matters in law because it often separates a bad outcome from a culpable pattern. For tort claims like defamation or abuse of process, intent becomes the hinge. To win, Viola's team had to show not just that Brett's words were damaging, but that the damage flowed from a plan to manipulate public perception. That was where Discovery's slow arc found speed. Arthur's subpoenas returned logs from the PR firm Brett used, schedules, draft tweets, and an audio clip where Brett could be heard telling an account manager to prioritize the cable hits at 9. A time-stamped email thread showed the firm discussing narrowing the target and using the city's own press machine. The metadata tracked when attachments were uploaded and who accessed internal documents. Small things, administrative and unimpressive on their own, became the sinew of a larger claim when threaded together. A neighbor, Mrs. Gable, who lived across the street from the municipal building, became a witness by accident. She had watched Brett walk away and later noticed him on her stoop, phone to cheek, laughing quietly as he spoke. She testified under oath that he had said, "Watch how fast it folds," and that he had a smile that made everything he said feel like the truth. The jogger, Leo, provided his original file. He listened to the lawyered answers and kept his phone at the ready. He said he'd meant only to record a moment he found mean. He had no idea the video would become a central exhibit. Every time the team added a document, every time a witness testified, the world outside leaned in. Social feeds multiplied lines of commentary. Podcast hosts invited talking heads who parsed legal possibilities for listeners who liked to tune in at the chorus line of controversy. There were late-night jokes and earnest panels. There were threads that connected Brett to unnamed influencers, to unnamed donors, to unnamed power brokers. Through all of it, Viola worked. She wrote briefs that explained legal doctrine with plain sentences so a juror could understand why a smear campaign was not merely unkind, but legally actionable. She explained malice in a paragraph that read like a human measure. Repeated, calculated choices to harm a professional reputation for benefit. She explained the mechanics of abusive process, how someone can use legal filings not to obtain a rightful remedy, but to coerce and to intimidate. She was precise where others wanted noise. Some of her colleagues counseled caution. The legal system is often unsympathetic to drama. Lawsuits are expensive and reputation fights can re-traumatize. One partner suggested she accept a settlement quiet enough to let life resume. But Viola had seen too often what quiet settlement does. It leaves a lie uncorrected and sets a precedent for the next attack. This, she told Elena, isn't about me. It's about the record. It's about the next woman who walks into that rotunda. And so she pressed on. Brett's strategy, meanwhile, shifted between defiance and increasingly erratic PR. When the firm realized discovery might expose internal communications, the public line became louder. He was being punished for being a good lawyer. He appeared on television and said things that his counsel later wished he'd not said. In one interview, he leaned forward and said he was proud to have stood up for his client against activist litigation. He laughed, again, at the memory of the rotunda. The clip from the interview would become, in Discovery, a moment of his own undoing. Small misstatements matter. A flippant remark about calling in favors became a line the civil team returned to, looking for corroboration. Were those favors jokes or evidence of leveraging influence? A pattern is not built on one line. It is built on multiples that point the same way. The city, feeling the pressure, initiated an internal audit of the contracting process Viola had challenged. That audit was thin, predictably focused on boxes and line items. The city withheld raw data for weeks. But the audit's existence forced the mayor to distance himself from knee-jerk defense of Brett and gave city council members the cover to ask uncomfortable questions. A gentle cascade of oversight had begun. Inside the firm's conference room, someone burned through their list of allies. A mid-level partner called and whispered that there were worries about cases on the docket and whether large corporate clients would faint at proximity to controversy. Privilege and money move conversations in particular ways. Brett, who had been used to others deferring to him, now fielded calls that suggested anxiety rather than loyalty. At a routine scheduling hearing, the judge, an older jurist with the patience of someone who had seen the theater of law before, glanced at the press pack and then at the parties. He reminded both sides that the courtroom was a place for facts, not spectacle. The admonition mattered only so far as courts can keep their own procedural rhythm. The deposition rooms, the subpoenas, the metadata audits, these are not glamorous scenes, but they are where games end. Elena found a string of texts between Brett and a junior publicist who had bragged about landing the talk show and starting the trend. That publicist's notes, when paired with the PR schedule, showed who promoted the story at what time. Another subpoenaed server log showed a pattern of access that coincided with news cycles. It looked, when arranged in a timeline, like choreography. Then, in a quiet inbox 3 weeks later, an email arrived that would later be called a pivot. It was a short message from a now former associate at Brett's firm, sent without the firm's legal email header. The subject line was empty. The body was one sentence. I don't like what we did. There's a thread with the dispositions. I'll share it if you need. That file contained versions of the press release with edits that removed caution and added accusation. It contained a track change in which a partner had written, "Make her the face. Make it stick." The language was cruel enough to fit the narrative that Brett had desired, an explicit strategy rather than an instinctive slip. It would be a difficult thing to explain away. Newsrooms loved such discoveries because they read like narrative arcs. For the legal team, it was the kind of evidence that might survive the objections of motion practice. It was not everything. It was not proof in itself, but it changed the air. Brett, who had been so sure of the laugh, began to notice the cluster of attention moving toward his firm rather than away from it. He altered his approach. More interviews, more defensive statements. He did not stop tweeting when the heat rose. He did not consider, for reasons of temperament or hubris, that silence can sometimes be armor. Viola, for her part, continued with the work only she could do. She prepared for depositions with the focus of someone who knew exactly where the testimony had to land. She drilled on timelines until they felt like muscle. She watched every clip of the rotunda, every angle of Brett's laughter, and she cataloged contexts, annotations, and witnesses. If litigation is a long game of chess, she had begun to see several moves ahead. As discovery widened, they found more than PR memos. There were invoices that suggested the firm had paid for expedited research into background pieces about Viola's previous clients, materials that could be used to feed a narrative of impropriety. There were notes that suggested outreach to friendly columnists. There was, earnest and banal, a spreadsheet where someone had tracked influence points, that is, outlets, hosts, and blogs, with scores assigned. Legal teams used imagination and evidence in equal measure. They imagined what a speculative plan looked like. They found the paper trail that made the imagination plausible. A turning point in the early campaign came when a junior partner at Brett's firm, alarmed at the exposure, sought immunity to cooperate. She described a meeting in which Brett had proposed a strategic narrative, a phrase that, in court, is dangerous because it describes an intentional plan to shape public perception rather than a benign communication. Make it about the person, the junior partner testified under oath, not the policy. Make it about her character. When asked why the memo used the word target, the junior partner shrugged and said, "That was the language everyone used in the firm." It sounded less like an excuse and more like a confession in the sterile light of a conference room. The phrase that would sting later, "I want it to stick," had been recorded in a draft memo. The memo sat now in discovery folders like a bright stain. In law, the difference between a stray opinion and a pattern is what you can prove in front of a neutral finder, a judge or jury. Documents help convert suspicion into evidence. Brett's deposition, which came later in the calendar, was a different beast. He had not expected to be seized by small details. He had not expected to be pressed into explaining why certain phrases appeared, and he had not expected that the casualness of his earlier comments would become the thing that unstitched him. The strategy that had worked in courtrooms, confidence, performance, did not translate well into a room built to memorize answers. "Let me ask you about the email on August the 5th, Viola's counsel began, calm as a surgeon. "There is an edit where you changed concern to allegation. Why make that change?" Brett smiled the smile of a practiced man who had handled more complicated lines of questioning before. "I wanted the language to be precise," he said. "That's what lawyers do." "But the earlier draft," the counsel continued, "said expose rather than address." "Exposure," Brett corrected, then softened it as if clarifying a misheard word. "We didn't intend harm. We intended to inform." On the recording, his laugh, light, offhand, gave the lie to no intent. People laughed in rooms when they felt superior. Juries later look for why. A casual laugh is not evidence alone, but it speaks in the room where behavior is being measured. By then, the story had folded into the public imagination in neat chapters. Accusation, humiliation, the internet's verdict, the slow detective work of discovery, and now, the embarrassment of a high-profile lawyer being asked to explain himself. That embarrassment in a world that loved spectacle was its own currency. The headlines that week read less like instantaneous judgment and more like a cautionary tale. What happens when the weaponizer of public opinion becomes the object of investigation? Would the law, itself slow and cumbersome, catch up? There were warnings, voices who said legal processes are not the same as public catharsis. There were others who used the moment to ask for structural reform, stronger regulations about coordinated media campaigns and litigation, more transparency in how firms used PR firms. Whistleblower protections for junior associates who might reveal internal strategies. These were the long arcs that would not be resolved in a deposition room. Viola's team, pragmatic and relentless, began to thread these public policy conversations into their strategy. When you can show not just malice, but a systemic method for weaponizing communications, you are no longer confronting a single man. You are confronting an industry practice. The difference matters if your goal is not merely compensation but prevention, and yet none of that was guaranteed. Courts are conservative institutions. Judges value precedent, not indignation. A libel claim is not the same as an ethical failing. For every piece of paper Viola's team produced, the other side had counsels who could frame context. The law hates assuming motives. It likes demonstration of facts. Despite this, momentum crept toward a public reckoning. The mayor announced he would support limited reforms, transparent releases for municipal inquiries, new rules about how law firms could communicate with city officials. Small wins, but wins nonetheless. The press loved them because they suggested movement. For Viola, they were a second-order satisfaction, not the goal itself, but a sign. Brett did not panic so much as double down. He appeared at a charity gala and made a joke that landed somewhere between hubris and breathlessness. A video of him tipping a wine glass and saying, "They'll come around," spread with the kind of sardonic subtitling that modern outrage traffics in. It did not help. The case evolved into a look at influence, how legal arguments can be shaped not only in filings but in tweets, late-night appearances, and staged press conferences. If the law is about evidence, the modern theater of public opinion is about placement. Viola's team sought to prove that placement was intentional. There were human moments too, beyond the legal scaffolding. Viola fell asleep at her desk once with a stack of exhibits for the following day's hearing still open. She woke with a pencil imprint on her wrist and a mind that had catalogued every possible objection her opponent might raise. Elena found herself scanning comments on the viral clips for hours, with sickness and fascination. People had turned the situation into a parable about power. Some of the comments were merciless. Some were empathetic. Elena read them all the way down because discovering what the world believes about a story helps you decide how to write about the truth. Outside, Brett felt the social tide. Former allies counseled him to take down his social media or to hire a different PR firm. He paused to reconsider one mid-afternoon, thumb hovering over the delete button, then changed his mind and left the post. It fared poorly. And then, in a moment that the reporters circled like vultures around a carcass, one of Brett's own podcasts released an unedited clip where he could be heard, distinct, unguarded, saying, "I knew if she flinched, it would end her." The sentence landed like a verdict in listeners' ears. The recordings were technically hearsay outside court, but in the court of public opinion they were immediate. Viola's lawyers took the audio and cleaned it, verified provenance, and prepared to use it in filings where admissibility would be tested. The clip was not a legal knockout by itself. It was, however, a prism that made motive clearer. Motive is often what converts an ugly action into a pattern of abuse in legal narratives. This is the part of the story where two things are true. One man had used his craft to humiliate another, and a diligent legal process was beginning to reveal how and why. Neither outcome was inevitable, but both had been set in motion by a single, bright laugh. The heat was rising, but the case still lived in the realm of pre-trial skirmishes. For every document Viola's team produced, Brett's counsel raised objections. For every witness they prepared, the other side brought in their own array of experts to frame narrative context. The law, being careful where the court of public opinion is not, demanded precise motions and careful framing. Yet beneath these motions a simpler human story played. Reputations are not only legal assets, they are the scaffolding of a life. When someone with charisma and platform decides to attack, when that attack is designed and boosted, the consequences ripple beyond laws into families, into friendships, into the small and terribly important rooms where people rehearse the ordinary. When Viola walked into the courthouse one morning later that week, there were cameras. She moved through them like someone used to scrutiny, but her face was not a performance. She allowed herself a small, private thought, that she hadn't come to litigation to be a spectacle, She had come because she believed the record mattered. That truth, once placed in an institutional frame, has the capacity to change more than one case. She had come because she wanted, in the only way the legal world generously allows, to make a public account. And still, even as the evidence piled, Brett kept laughing in clips that would not die. That laugh was a loop on a phone screen, a meme, an audio bite that people could share in the middle of breakfast. It was, for the world, a shorthand for privilege. For the lawyers, it was a sound cue. For Viola, it was a thing to be catalogued, understood, and answered. On record, on the morning it mattered most, Brett's own voice stung him. During a motion hearing, a small audio clip of his unguarded comment was played in open court, not as theater but as evidence in a hearing. He flinched. Not because the sound was unpleasant, but because the system had turned the tools he had used into counters against him. The room registered the flinch. The public recorded it. The feeds, already hungry, amplified it. This is the place the first months of the case reached. A place where the courtroom's careful logic pulled against the blunt force of public sensation. The lawyers on both sides prepared briefs and filed responses. The judge admonished counsel to keep spectacle out of legal filings. But spectacle had been present from the moment Brett had laughed, and it could not be entirely removed now. The live video had already done its work. It had demanded an account. If the first act is humiliation, the second is proof. That proof comes in the slow, patient accretion of documents, emails, and witness testimony. Viola's team had started to assemble those pieces. The city had begun to ask questions. The bar had quietly opened a file, and somewhere deep inside Brett's own firm, someone had misgivings. There is a small human beat here that matters. Brett, alone in his office one late night, looked at the laugh clips for the first time without a smirk. He did not like what he saw. It was not the laugh that bothered him. It was the way it had, in a single gesture, turned him into someone else, a symbol. He closed his laptop and lit a cigar in his sink of a balcony, the smoke curling into the night. He told himself he was not worried. He believed still in his talent for managing narratives. He believed the legal system favored men like him. But belief is not a legal strategy. As the weeks blurred toward pretrial, Viola stood with her team and made a choice that would define the arc of both their lives. They would not accept an off-the-record resolution. Instead of signing non-disclosure agreements and letting the worst parts of the story evaporate, she insisted they pursue the whole record, even if it meant a long fight. She wanted the documents to be public, the transcripts to be on record, and the conduct to be judged openly. Some things, she told Elena, are worth more than money. The truth is one of them. The decision was consequential. It turned the case from a private spat into a public treatment of professional misconduct. It also escalated the stakes for Brett, who had relied on silence and private settlements as a shield. Discovery continued to yield uncomfortable evidence. A draft invoice suggested that the firm had contracted a third party to run background checks and to seed alternative narratives into blogs sympathetic to their clients. A text message from a former firm associate admitted, "We pushed the story hard. It was coordination." When those words reached the desk of the opposing counsel, they waited like bait on a hook. What followed was a legal rhythm that would take months and later years. Motion practice to exclude certain evidence, fights over privilege claims, issues about whether communications with media partners were protected advertisement or evidence of a campaign. There were motions to quash subpoenas, appeals to the judge, and the mundane arithmetic of legal bills that ran higher every day. At the center of it all was the human cost. Viola's children, grown but tethered to her by more than half a life, took calls from friends. Her emails filled with a mixture of support and solicitations. She found herself replaying the laugh and refusing to let the sound become the only thing that defined her. Meanwhile, people began to wonder about the systems that allowed such a spectacle. To spin out of a single, gleeful moment. If one laugh could catalyze investigation and outrage, then what else in the ordinary machinery of influence might be hiding behind polished releases and friendly pundits? That question, quiet at first, would drive the next phase of the fight. If you want to see how the woman he humiliated would one day sit in judgment over the world he'd helped build, stay with the story. The pre-trial months folded into a sequence of smaller dramas that felt, to those inside them, like trenches. There were argument days where the judge, patient and firm, asked lawyers to take the moral theater out of their motions and hand him only the law. There were piecemeal rulings that admitted some evidence and excluded other pieces. There were long nights where Elena and the junior associates annotated transcripts until their outlines looked like city maps. The civil complaint Viola filed was precise. It named defamatory falsehoods, tortious interference with her professional relationships, and the intentional infliction of emotional distress. It alleged coordination with the firm's public relations operation and claimed that the smear campaign was designed not to litigate points of law, but to manufacture a public reality in which Viola's integrity was impossible to salvage. It read like a legal portrait of manipulation. For the defense, the playbook was familiar. Contest admissibility, raise privilege where possible, argue context. Their counsel painted the press releases and television appearances as ordinary advocacy, zealous representation in a contested public matter. The difference in tenor was small on paper, enormous in the air. One side insisting on truth as process, the other insisting persuasion does not equal wrongdoing. Discovery remained the theater where truth, its messy, incriminating self, tended to trip over its own tracks. The documents that had once been only administrative dockets now read like a script someone had written in haste and carelessly saved. Billing entries that once had no eyes on them were suddenly subpoena fodder. Research placement, press coordination, background due diligence. In one set of emails, a mid-level associate attached a spreadsheet with a column labeled Outlets to Seed and another labeled Priority Hits, Morning Shows. In another file, a handwritten note on a printout read, Make narrative personal, use examples. At a deposition months into the case, Brett sat across from a court reporter and a video camera, the lawyer who had weaponized narrative now forced to explain his own. The room smelled faintly of coffee. Outside, feeds churned with summaries and hot takes. Inside, the small gestures mattered. The way he rubbed his forehead, the way his voice would tighten when asked about specific emails. Is it your practice to coordinate with media outlets on matters connected with filings? Viola's co-counsel asked. Brett took a breath, inclined his head like a man who believed he was above entanglement. We use communication strategies to explain our positions, he said. It's advocacy. Did anyone in your office ever discuss targeting an individual with a press release rather than discussing the policy in question? Targeting isn't the operative word. We frame narratives to make complex issues accessible, Brett replied. He smiled. He sounded practiced. Can you explain why a draft press release from your office had the phrase, make her the face, in track changes? The counsel pressed, sliding a printed email across the table. On the recording, Brett's smile thinned. For the first time since the rotunda, something in his composure cracked. I don't remember that phrasing, he said. You'd have to show me the document. They did show it. He squinted at the ink like a man scanning a distant landscape. I don't recall approving that exact language, he hedged. A pause. The court reporter took it down. The deposition tape saved the inflection. That pause, small and human, was the knot the plaintiffs had been working toward, a moment in which planning and deniability intersected. In civil litigation, intent is often the mountain you have to summit. To win on claims like tortious interference or intentional infliction of emotional distress, the plaintiff must show more than a mistaken statement. She must demonstrate that the defendant acted with a purpose that went beyond advocacy. The discovery trail that led from strategic memos to phone logs to a junior associate's confession provided the map up the mountain. One document, an innocuous internal memo, became pivotal. It was dated a month before the Rotunda incident and sent on firm letterhead to a small list of partners. It outlined narrative strategy and included a bullet list of desired effects. A redacted line, when finally revealed, read, Make the person the story, focus on biography, Create edges people can believe. On cross-examination months later, the junior publicist who'd drafted the memo sat in a chair with her hands folded. Her voice shook for a moment before settling into clarity. She testified that she had been coached on what language would resonate, that she had prepared drafts expecting approval, that she had been told to prioritize host-friendly copy. She told the court she had felt uneasy when the memos repeatedly used language that edged from advocacy into character assault. The testimony read like a missing piece clicking into place. The cumulative effect of those documents and depositions was to show a pattern, narrative creation, deliberate targeting, and then a rollout intended to create a reputational effect. For jurors, ordinary people asked to translate legal doctrine into a common-sense judgment, seeing a spreadsheet with priority hits or hearing a recording where Brett said, "Make her look inevitable," did not require a degree in jurisprudence to understand. It read like intent, but law is careful, and the other side fought hard. They argued hearsay. They argued that internal drafts were tentative and exploratory. They argued that a lawyer's duty to clients justified aggressive PR. Judges, who see the law as a test of proof rather than a platform for moral gut reactions, waded through objections and admissibility hearings with steady pens. When the case finally reached the jury, the courtroom had become a stage with rules. The judge instructed the jurors to set aside the chorus of social media and to consider only what they heard in the courtroom fits the legal definitions they were given. Viola watched as the jurors took pages of notes. She thought of her father's face in that small black and white frame on her desk. Steady, unshowy, the kind of guidance that sits behind a person in moments when the world is noisy. The trial itself unspooled like an evidence-driven drama. Videos played, Leo's original clip looping on a screen, slow and unadorned. The audio was cruel in its simplicity. Laughter, the slight rustle of paper, microphones catching the moment. Witnesses took stands and testified about tiny details that collected became a tapestry of motive. Elena, who had logged more hours than she would ever count, put a witness on the stand who could speak to the timeline of the press release's drafting. Her cross-examination was crisp and deliberate. She asked questions in short sentences and let the witness's answers hang in the air. Each small admission, about who had edited a line, who had pushed for a cable segment, who had called the morning show, felt like a new seam in the defense's carefully built facade. Brett's defense tried to humanize him. They called character witnesses, a former client who praised his tenacity, a colleague who described late nights and long hours, a philanthropic board member who spoke of donations. The strategy was classic. Recenter the man as a complex human being beyond the viral clip. It worked in parts. People are inclined to see nuance. But a jury is also made of patterns. The highlight of the trial, the moment the spectators would later call the fulcrum, arrived during cross-examination when Viola's team played a string of internal audio clips. In one, Brett was heard on a conference call saying, without an attempt at subtlety, "If she cracks, we own the narrative. We don't have to win on law, we win on story." It was the kind of line crafted to be a smoking gun. Even his counsel winced. Brett, on the stand, tried to shore up his earlier phrasing. "We use language," he said, "to advance our client's interests. I didn't intend to destroy anyone's life." "Did you intend for your communications to cause people to view her as untrustworthy?" Viola's counsel asked. "To view the contractual questions critically," Brett hedged. "Did you instruct anyone to draw particular attention to her personal background to make it harder for her to practice?" the counsel asked. The question measured. "Not to my knowledge," Brett replied. The jury listened to the playback of messages and to the testimony of staff, who described rehearsed narratives and quick promotions of material to social platforms. They heard Mrs. Gable describe Brett's offhand comment on her stoop, and Leo describe instinctively tapping his phone and uploading the clip without second thought. They saw the metadata that showed the firm had pitched a segment on a specific morning show minutes before the press release went live. At the end of a trial that stretched across weeks, the jury retired. The waiting felt like a held breath in the courthouse. The clerk read the verdict in a voice that sounded too small for the weight of the moment. The jury found for Viola on defamation and on tortious interference. They awarded compensatory damages and a punitive element meant to both punish and deter. The punitive award was more modest than some in the public expected. Courts are constrained in how they apportion punitive damages. The sum nevertheless landed like a formal repudiation. It was a public ledger entry. The law recognized not only the harm, but the calculation behind it. The judge added a written finding that, in the calculus of civil law, the defendant's conduct had crossed lines that merited more than mere apology. But a civil verdict, dignified as it may be, is only one part of professional accountability. The Bar Association's disciplinary process moved at its own pace, deliberative, bound by procedural protections for attorneys, and governed by different standards of proof. Yet the same documents that had helped secure the jury's verdict were now folded into the bar's file. Emails, memos, recorded statements, witness testimonies. The regulators had, publicly, more discretion in consequences than a civil jury. The bar's hearing was less theatrical than the trial, but perhaps more consequential for Brett's career. Former colleagues testified. Junior associates described pressure to conform to narratives. PR staff laid out timelines that suggested intentional placement. The bar's disciplinary panel found that the lawyer had engaged in conduct unbecoming, had weaponized public communications in ways that failed to uphold the profession's ethical obligations, and had engaged in conduct that threatened the administration of justice by using publicity to coerce outcomes. Ultimately, the panel recommended severe sanctions. Disbarment was pushed by some members, suspension by others. In the end, faced with a mountain of documentary evidence and with the public scrutiny already acute, Brett's firm terminated him. The bar revoked his license. It was a slow institutional death. Clients left, partners distanced themselves, speaking engagements dried up. Where once his name opened doors, it now read like a cautionary tale in trade magazines. Karma in this story did not arrive as a single lightning strike. It was a drip of consequences. The firm lost key retainers. A few months after the verdict, they announced a strategic realignment and cut ties with high-profile clients who feared association with a firm under scandal. Financial pressures led to layoffs. Brett found himself with more time than clients. With more time came gravel and thinking. The public's appetite for spectacle declined as the news cycle moved on. Social feeds churned new targets. Talk show monologues sought fresh material. But the structural shifts lingered. City councils adopted new transparency rules about press releases tied to government investigations. The mayor's office instituted a policy requiring press materials tied to public inquiries to be vetted by an independent counsel, language drafted in part by staff who had watched the case carefully and wanted a buffer against manipulation. At the state level, a modest bill, narrow and carefully phrased, introduced disclosure requirements for law firms that coordinated media campaigns with government actors. It did not outlaw narrative strategy. It required documentation and reporting for campaigns tied to pending government inquiries. It was a small lever, transparency rather than prohibition. Viola testified in committee hearings about why a record mattered. Her testimony was calm, clear, not vengeful. When you make reputation a commodity, she told legislators, you erode the public's faith in adjudication. Records give the public a chance to evaluate. The reforms were hardly sweeping. They were, in legal terms, incremental. They forced, however, an industry to account for what it did when it chose to make litigation a public spectacle. Journalists appreciated the changes because they created a paper trail for future investigations. Law firms grumbled but adjusted. Junior associates felt safer. Some reported that they were less likely to be asked to create narratives without documentation. The bar introduced internal guidance on the use of third-party vendors for media placement. It was not a revolution. It was a set of guardrails. As for Brett, the career that had relied on visibility and swagger now increasingly depended on low-level consulting. He gave talks at small private events about the art of persuasion and took freelance work advising clients about communications, work for which he received modest fees. His name, once a marquee, now sometimes carried the whispered framing, former. He moved to a smaller office, accepted that his social circle had narrowed, and found that the world had a new patience for his old jokes. The human cost tracked both ways. Viola had not become a celebrity through the trial. She had become a person marked by the experience and by an obligation to herself and to other practitioners, not to let the lessons vanish. She returned to her practice but also began to invest energy in wider institutional work. She sat on a municipal oversight board advising on disclosure policies. She mentored associates on ethical media strategies. She lectured at law schools about the perils of conflating persuasion and harm. Elena, who had been by her side from the early days, left the firm a year later for a clerkship, and then for a judicial fellowship. The fight had made her resolute. She wanted to be part of the machinery that built rules rather than only litigating them. Arthur Sterling, the old friend who had lent credibility to the subpoenas and who had helped the team open doors, wrote a short essay on professional responsibility that was widely circulated in legal circles. Mrs. Gable and Leo, the unwitting witnesses, returned to ordinary life with the oddness of being remembered by strangers on social media. Time, always a sculptor, rearranged priorities. Viola, who had never sought public office, began to feel a quiet call toward the bench. The local judicial seat opened when an aging judge retired. Friends urged her to run. She hesitated. She loved the work of lawyering, the craft of argument, but the idea of shaping how courts navigated the intersection between public opinion and legal process appealed to her restraint. A chance to set standards for how evidence and exposition should coexist without becoming a PR racket. Her campaign was modest. She emphasized experience, impartiality, and a belief that courts should remain sober forums for fact-finding. She did not wave the case like a banner, but she did not hide it either. In debates, she spoke about integrity and process, about how the best remedy for spectacle is a better record. Voters, fatigued by partisan noise and responsive to a candidate who articulated clear guardrails for public life, elected her. When she took the bench, people noticed how slowly she moved through robes and dockets. She brought the same temperament she had shown through litigation. Calm, precise, argumentative, only when needed. She resolved disputes with a preference for careful opinions that scholars could read and practitioners could cite. She wrote with clarity, because she believed a judge's words should furnish the next lawyer with the scaffolding they'll need. Several years after her election, a new case came before her court that tested the line she'd been thinking about since the rotunda. The case was not the same civil suit she'd won. She had recused herself from any direct involvement with her prior litigation. The new matter involved a high-stakes dispute about the admissibility of coordinated communications as evidence in professional misconduct claims. It stemmed from a separate incident in which another firm had been accused of seeding a defamatory narrative tied to a public investigation. The appeal rose to a point where the court needed a clear statement on how to treat such communications. Were they merely context, or could coordinated media strategies be evidence of improper intent, sufficient to support disciplinary action? Viola had been careful about appearances. When the case came on, she disclosed her history and recused herself from any panel directly connected to her prior actions. The court, however, assigned her to a separate merit panel that handled appellate questions about evidentiary standards in such cases. The question before her and her colleagues was path-shaping. When does advocacy cross into professional misconduct, and how should courts weigh media coordination in that calculus? Her opinion, crafted in long hours, annotated by clerks and argued in conference with judges who prized precedent, was measured. She began by laying out the stakes: freedom of speech, the advocacy role of counsel, the need to protect reputations, the duty of lawyers not to abuse public foray. She cited the civil verdicts and disciplinary outcomes in the earlier case only as context and confined her reasoning to legal principles. Pulling from doctrine, procedural rules, and policy considerations, she wrote that coordinated communications may, under certain circumstances, be probative of intent when paired with other evidence, showing a plan to coerce or to avoid fair adjudication. She emphasized standards, proof, causation, proportionality. The opinion did not invent a cause of action. It clarified how existing rules should apply. For many observers, the opinion was the point where she became truly his judge, in the sense the headline had once promised. Brett, by then a cautionary tale, read the opinion like many did, with a sense of a world in which his species of tactics had been circumscribed. The opinion upheld the idea that communications can be evidence when coordinated with an intent to drive a narrative at the expense of due process. It made clear that attorneys entrusted with public persuasion bore responsibility when that persuasion intentionally targeted private reputations as instruments rather than when it argued legitimate policy. It was not personal. The court did not mete out vengeance, it set boundaries. Viola's voice in that opinion was legal and formal, not triumphant. She wrote, in a paragraph that would be quoted in legal journals and by colleagues, that the integrity of adjudication depends not on the absence of argument but on the presence of honest process. The line circulated not because it punished one man, it was broader. It taught systems how to better police themselves. Brett watched the aftermath of the opinion with the same odd combination of melancholic analysis and professional pride that had guided him for decades. He believed, like many before him, in the power of rhetoric. Now the rhetorical field itself would demand more accountability. He considered writing a piece on changing mores in legal advocacy, but found no audience large enough to sustain a comeback. In the months after the court's opinion, bar services across the state updated their ethics guidance. Law schools added case studies that asked students to think not only about what a powerful argument could win, but what it might cost. Firms developed internal protocols for media engagement tied to pending governmental or adjudicatory matters. The changes were incremental, but they altered behaviors that, for years, had relied on opacity. For Viola, the culmination of the arc was less about headlines than about a kind of quiet proof. The rules she had hoped to shape were being written into practice. She still took cases early in her judgeship, pro tem appointments and pro bono reviews, but she spent more time on administrative work, appointing panels, editing procedural rules, mentoring young clerks. Her office walls still held the same photo of her father, now slightly faded. Sometimes late at night she would sit with a stack of opinions and remember the rotunda's laughter, how a small personal affront had pushed her to articulate public standards. She did not gloat. There was no gloating in the way she walked the halls of the courthouse or in the manner she received letters from law students who said her opinion had helped them think about the ethics of persuasion. That steadiness was perhaps the quietest part of the sentence Brett had already begun to serve. Accountability, in her telling, need not humiliate. It need only be sustained. Brett's decline was not cinematic. Taxes still had to be paid. He moved into consulting for small clients who wanted tips on messaging, though those clients rarely commanded the kind of platform he once enjoyed. Friends asked if he was bitter. He said he was reflective. He found odd work advising nonprofits on public-facing documents and gave speeches at small universities on the ethics of public advocacy. People in the industry still quoted lines of his old pre-scandal op-eds to make points, none of which made him easy company in rooms where reputations were currency. The human cost lingered in ways that money cannot always fix. Viola had to rebuild a sense of professional ease that the smear had damaged. She had to navigate the awkwardness of clients who met but whispered. She found, though, that the litigation changed something else. It sharpened other people's awareness. Young lawyers who watched the trial learned how to document strategies and how to insist on written approval for public engagements. Some firms institutionalized a red team review for media plans, asking skeptical partners to gauge whether a line crossed from advocacy into harm. Years later, at a modest ceremony marking the passage of a law that put disclosure obligations into a municipal code, Viola stood quietly at the back as the mayor praised the collaborative work that produced the language. She listened as Elena introduced her, not as a victor, but as a steward of standards. The applause felt small and wanted. It was the applause that follows method, not melodrama. In a final scene, which would be recalled in profiles of all parties years after the case, Viola sat in a small cafe near the courthouse. She stirred her tea, watched a group of clerks crossing the street in conversation about an upcoming oral argument, and allowed herself a private thought. That the law is at its best when it contains not just answers but processes, when it channels indignation into reform. Her face in that out-of-frame moment was not triumphalist. It was instead the stoic look of someone who had seen what misuse of power can do, and had spent herself trying to build something sturdier. Brett passed through his own reflective years. He had nights when he rewatched his laugh and shuddered at its particular cruelty. He sat with the quiet knowledge that reputations, once weaponized, leave a trail not easily cleared. He started a habit of reading judicial opinions, Viola's among them, not with the combative joy of someone awaiting a misstep, but with a slower interest in how law reconfigures social expectations. The city, the bar, and the modest state reforms together produced a future where tactics similar to Brett's would carry new costs and new scrutiny. The clear record left behind by Viola's insistence on making conduct part of the public ledger meant that future counsel faced a harder choice when considering whether to weaponize publicity. If there is a moral to a story like this, it is not punishment as spectacle. It is the slow assertion that systems can be altered when determined people insist on record and law, and when they direct the public's attention toward structures rather than into vendettas. Viola's path from the rotunda to the bench was not a revenge story. It was an evolution. Hurt transformed into rules, humiliation into guardrails. In the end, the man who had laughed in a marble hall lost the status that had let him perform so freely. He did not break on a public pyre. He faded, adjusted, and learned, whether genuinely or not, to measure the echo of his rhetoric. She, the woman he had tried to make small with a laugh, became a steward of the very forum where such echoes are weighed. She had become, in every formal and informal measure that mattered, his judge. Was the punishment enough, or should accountability carry different penalties? If this story moves you, leave a comment and tell us what you think. If you want more deep dives into courtroom battles and the changes they drive, like and subscribe. There are more stories like this waiting to be told.